All right, the wonders of technology. Moving into the next phase. Thank you. Thanks, Whit.
Thank you.
Thank you, everyone, for being here. This is the Roberts Court and race, and unlike our previous panel, where we understood how the court is kind of lurching in different ways, still working out where it stands on major questions and other aspects of administrative law, there has been a very consistent through line for the Roberts Court on race. So we're going to explore that with a couple of major cases right now and talk about where the court might go with these cases, but also if there will be any hedging at all in terms of how John Roberts sometimes likes to balance a bit. First, I'll introduce our panelists, and I'll start with Janai Nelson with the NAACP Legal Defense Fund, who will be with us from Zoom. You can see us, Janai. And then to my immediate right is Pam Karlan, now of Stanford, at times with the Department of Justice. We have Pratik Shah with Aiken Gump. We have Jeff Wall with Sullivan and Cromwell, also formerly of the DOJ as an acting Solicitor General. And finally, Erwin Chemerinsky from UC Berkeley. And this is a panel that you should all be in awe of because they have all been at the center of issues on both sides, mainly on one side, but we're glad we have Jeff here to really channel kind of where the Roberts Court might truly be on some of these issues. So a valuable voice. We're going to start with the Harvard and UNC cases that were brought by the challenger students for fair admissions. Then we're going to go to a voting rights case that I think has been a bit overshadowed by the case that we did the moot on last night, but that is so important and that will be argued the second day of the term, the Alabama voting rights case that tests where the court might go on Section 2 of the Voting Rights Act. And then we're going to have some broader thoughts on the Roberts Court and the Voting Rights Act overall. And then we're going to go to the Indian Child Welfare Act, a case that some of you might not be familiar with, but is another one that has strong racial implications. And then we're obviously going to save time for broader thoughts about this court with our first African-American woman justice, and then take questions from you too. But let's just start with the Students for Fair Admissions challenges to Harvard and UNC. And the NAACP Legal Defense Fund has been hovering over this case and been involved since it was actually filed in November 2014. It was filed by a man Edward Bloom, who delivered Shelby County to all of us. And he has been very much in sync with where this Roberts Court has been developing. But we're going to start with Janai to kind of set up those cases, talk about how she thinks that Harvard and UNC can potentially fight off this challenge, and then we'll go to Jeff Wall for some context on the other side, and then thoughts from the other panelists. Janai?
Thank you, Joan, and it's wonderful to see everyone. I have so many friends on that panel. I'm sorry that I couldn't be there with you all in person, but thanks for accommodating me on Zoom. Let's jump right in. You're right. The Legal Defense Fund has been actively involved in the Harvard case, as well as the UNC challenge. And frankly, every case that has gone to the Supreme Court on affirmative action and higher admissions since 1978 with the Bakke decision. This will be the sixth time that the court has to revisit the question of whether universities can consider race in admissions. And each time the court has considered this question, it has agreed that universities have the freedom to consider race in admissions in order to create diverse classes, which is the standard that Bakke set, as opposed to remedying past discrimination. But every time that this question goes before the court, affirmative action comes back a little worse for wear. It's a little narrower, it's a little more difficult for universities to navigate the terrain. And frankly, I think there's always a chilling effect because the field is much more complicated to navigate in terms of what leeway universities have. This case will go before the Supreme Court for oral argument on the 31st of October. So October will be a blockbuster month. As you mentioned, there's another big case that the Legal Defense Fund is involved in that we'll talk about later on the 4th of October that will be argued. But this case is complicated in a few different ways. There are two cases, as I mentioned, a challenge to Harvard's admissions policy and a challenge to the University of North Carolina. So you have one elite private university on the one hand, and then another elite public university. And the strategies for each case have been a little bit different from the Students for Fair Admissions, which we think is not aptly named. That plaintiff in the Harvard case has tried to create a wedge between Black and Latinx and Asian students and those communities, frankly, more broadly, by alleging that Harvard engaged in intentional discrimination against Asian students in allowing what is a very modest number of Black and Latinx and Native Indigenous students into its class. It has been a very, I think, controversial issue socially, but when you look at the data and you look at what Harvard has actually done and the very relatively minor role that race has played as a factor to decide among a pool of qualified students of every race, we realize how specious that argument is. The Legal Defense Fund has represented in Harvard 25 student and alumni organizations that comprise thousands of students of various backgrounds and alumni, faculty, et cetera. And all of those students recognize the value of having diversity in their classes and even in their alumni networks and what that ultimately produces. Similarly, in the UNC case, and I should note that originally these cases came before the court and they were consolidated. The court deconsolidated them several weeks ago, which was a welcomed event because, as you noted, we have a new justice on the court, Justice Ketanji Brown Jackson, and she elected to recuse herself from the Harvard case. And there was a lot of question about what that result might mean if the cases remained consolidated. So we were pleased that they were separate. And I think it makes sense because of the arguments that I just mentioned that are somewhat different with respect to Harvard and with respect to UNC. In UNC, there's been a greater emphasis on trying to manipulate the conception of Brown versus Board of Education, which is a case that the Legal Defense Fund litigated and won and ended legal apartheid in this country in terms of public school education. And that cascaded out into so many other spheres of our society. We, in that case, are amici. We are not representing clients in that case, but we have submitted an amicus brief, as we did in the Harvard case as well, noting that the suggestion that Brown is in any way colorblind is a mischaracterization of history and an entire manipulation of what the Supreme Court held in the Brown decision. And so we are pushing back against the narrative of colorblindness in the UNC case, and we think that those are ways in which these two cases are distinct in terms of how the court may arrive at what we hope will be another upholding of affirmative action. But we must recognize the risk that this court, and we've been calling it the Roberts Court. I'm not sure we can continue to call it the Roberts Court because I'm not sure what sway he continues to hold over the majority, the extremist conservative majority on the court. But nonetheless, I think that there are valid reasons to uphold affirmative action, that there's nothing that has changed in the law to merit this court abandoning over 40 years of precedent, that this would be akin to what happened in Dobbs, where the court has rejected without sufficient analysis standing precedent. And particularly when it comes to the interpretation of Brown, it would be a rejection of what many of the justices on the court have called super precedent. And so I commend our briefs to anyone who's interested in delving deeper into some of these issues and the differences between the UNC cases and the UNC case and the Harvard case. But the through line is that this is an attack on race consciousness in admissions. And I'll end by saying that the support for affirmative action by corporations, by the military, by scientists and so many stakeholders in our larger society continues to be extraordinarily strong. If you look at the array of amicus briefs that were submitted and the record number of corporations that signed on to support affirmative action, we recognize that this is something that many in our society recognize is still necessary for our advancement and for our success.
Thanks, Janai. In terms of the precedent, obviously we're talking about the 1978 Bakke case, so going back almost as far as Roe, and then the 2003 Grutter versus Gratz, both obviously decided by just a single vote. So we'll see where we're at now. I'm going to turn to Jeff Wall now to sort of give us some thoughts about where the challenges are coming from and where this court might be. I take your point that this isn't the Roberts Court in many areas, but when it comes to race, it is John Roberts who said, you know, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. And also a year before that 2007 comment said in 2006, it's a sordid business, this divvying us up by race. So he's been in this space, and I think that there is typically no way that he wants some sort of middle ground here, but I'll let Jeff address that.
Thanks, Joan. So first, I just want to say thanks to Allie and to William and Mary for having me. It's great to be here and see and be alongside of so many friends. So there are two questions in the Harvard case. The first is, does the 14th Amendment allow racial preferences at colleges and universities at all? The second is, if it does, is what Harvard's doing, is the way it's taking account of race, does it satisfy strict scrutiny, which is what the court has said is the level of scrutiny appropriate for racial classifications. On the first of those, I don't have anything to add to the briefs, which are both decidedly originalist, even Harvard's brief. They both have lengthy discussions of the text, the post-Reconstruction statement, statutes, the Plessy dissent, Brown, and so I'll let all of you kind of read those and make your own judgments about what you think about the 14th Amendment as an original matter. I want to focus more on the second question about what Harvard is actually doing, because I think it's tied to the first in a pretty important way, which is to say, if you look at what Harvard is doing and you have the reaction that it's inappropriate or not consistent with what the court said was permissible in Grutter and Fisher, then I think it tends to confirm the view that the challengers are pushing, that schools shouldn't be in the business of using race at all, which is to say, is Janai right that it really has had a chilling effect, the court's decisions, or that race really is a minor factor? If it is, that supports one view. But if that hasn't been true, even after decades of the court trying to adjust and make clear to schools exactly what they can do, it tends to push you in the direction of a broader ruling about the 14th Amendment. So a couple things to note first about the suit. Choosing Harvard was no accident. This is not Fisher. This is not Abigail Fisher and discrimination against whites. This is a claim that Harvard is discriminating against Asian Americans. And as Janai says, I think the challengers framed it that way in order that the optics and atmospherics of the case would be different. And I don't think it's an accident that they chose Harvard. In the 1920s, Harvard discriminated against Jews, and it did by moving away from a set exam to a more holistic admissions process. And what the challengers are trying to do in the case, or at least the allegation is that that's what Harvard did in the 1920s. And what they are trying to do is draw a parallel between that and what they say Harvard is doing now with Asian American students. They also are trying, I think, to draw on the justices' experiences. One of the cases is about a big state school, UNC. But the bulk of the ink and the briefing has been about Harvard. And that's the justices' backyard. Several of them attended Harvard. It's one thing, I think, to say, don't second guess how you do it at the University of Texas. I think it's another to say, here's what's going on at Harvard, and here's what's going on at the Ivies. And that may be a world where they're more comfortable second guessing what school administrators are doing. So the challengers say, I think, kind of three things, or they have sort of, I don't want to call them claims, but three arguments in support of their claim. The first is they say Harvard is racially balancing its class. And if you look at the statistics over the decade from 2009 to 2018, the racial composition of the class is fairly consistent. And by the way, the terminology I'm about to use is drawn from the briefs and the opinion, so I make no statement about it. African Americans range between 10 and 12% of the class each year. Hispanics are generally between 9 and 11% of the class. There's 1 year where, I believe 1 year where 8% Hispanic, 1 year where it's 12%. And for Asian Americans, it's 18 to 20%. I believe there's 1 year where it's 17%. So for the vast bulk of years across the decade, the numbers of those groups as part of the class are within a 2% range. Everybody agrees that the admissions officers can see the self-reported race of the applicants, and that they can also see on these things called one-pagers a lot of statistics about the current class as they've admitted it so far, including its racial composition. Now, Grutter said you can aim at critical mass to make sure that you have a critical mass of minority students in order to ensure that you achieve the values of diversity, but you can't achieve specified percentages. So which is this? Is it critical mass or is it specified percentages? The second is, how do the challengers say that Harvard is balancing its class? Their claim is that Harvard scores students in a number of different categories, and most of them are fairly objective, like academics, athletics, or extracurriculars. But there is a component that's fairly subjective. It's called the personal rating. And the argument is that the personal rating given by Harvard to Asian American students is systematically lower than for other racial groups. The district court, even though in general very favorable to Harvard, agreed with the challengers on that point, that there is a statistically significant negative correlation. So why? Why are Asian American students receiving a lower personal rating at a statistically significant rate? Harvard says, we're not really sure. There's no direct evidence that we're biased. Maybe there's bias filtering into the system from teachers' recommendations and guidance counselors. Maybe it's something else. We're not really sure. The challengers say, look, we controlled in the models for the teacher and the guidance counselor recommendations, and there's still a statistically significant effect. I think there's a lurking legal question here that turns out to be potentially pretty important, which is who bears the burden, right? If it's really, if no one knows exactly why, and there isn't any direct evidence, do the challengers have to prove up the claim that Harvard is using race in an impermissible way? Or does Harvard, having said it uses race, have to prove that it's not, in fact, discriminating when it assigns the personal rating? Harvard drops that issue to a footnote and says it's essentially irrelevant. We satisfy any standard. But I think potentially it's quite important because on the record, it's not entirely clear. And the district court said, I'm really not sure what's causing this effect. And then the third thing is there a race-neutral alternative that's workable? Something I learned from the briefs that I didn't know. Harvard, and this is undisputed, gives preferences to 4 different groups: recruited athletes, children of legacies, people who attended Harvard, children of donors, and children of faculty and staff. And what the challengers say is, if you drop those preferences and you give a little more preference to socioeconomically disadvantaged students, you end up with a class that has as good as or a better racial mix, and your academics don't change much and your SAT scores drop a little bit. Harvard says, no, yes, you still have a reasonably good racial mix, but the number of African Americans goes down, and not only do your SAT scores dip, but the academic strength of the incoming class is not as strong. So what does the court make of that? Now, maybe none of this matters. Maybe the argument is just a debate over like high theory on the 14th Amendment. But I think if some of the conservatives are being strategic at the argument, there are some hard questions for Harvard about what it has been doing with race that could push the Chief Justice and Justices Kavanaugh and Barrett in favor of a broader ruling on the first question about saying, look, schools should be out of, as the chief said, the sordid business of divvying us up on the basis of race.
Thanks, Jeff. You know, I'm glad you reminded everyone about how the challenges from back about 10 years ago using white young woman, Abigail Fisher, versus this challenge using Asian American students. The original 120-page complaint did not name a single Asian American student. And during the trial, Judge Burroughs, who I covered that trial, and it was interesting because Allison Burroughs was just new to the bench some 7-8 years ago when they held the trial in this case that's now coming up to the Supreme Court. And she actually rejected the claim that there's actual discrimination against Asian American students, actionable discrimination against Asian American students. So it'll be interesting to see if the court just accepts those findings or goes more in the direction that Jeff is suggesting, and asks the Harvard attorney, who's been in it from the start also, Seth Waxman, just about the practices at Harvard. It was one of those cases that in some ways aired a bit of the what goes on with selection in terms of legacies and donors, and the challengers have suggested that they could drop those categories, but I don't know if anybody here would believe that Harvard would ever drop those kinds of categories. I just want to hear from any of the other panelists who want to respond. Go ahead, Erwin.
Just a few quick thoughts. One is worth noting that the legal issue in these two cases is different. The North Carolina case obviously involves equal protection, but since Harvard is a private school, equal protection of the Constitution doesn't apply. It involves Title VI of the 19th Civil Rights Act that says that recipients of federal funds can't discriminate on the basis of race. In Bakke, 5 justices said that the standard of Title VI and equal protection are the same. It's interesting if they overrule Bakke, will they continue that aspect of Bakke? And in a footnote in Gratz versus Bollinger, Chief Justice Rehnquist said, we've said that the standard is the same. But that's not necessarily so. A statute, especially here, doesn't necessarily have the same meaning as the Constitution. And I don't know if they'll get into that or just assume the similarity. Second, I think it's really important how the court writes the opinion. I don't think that many people, liberal or conservative, have much doubt as to what the result is going to be. Given Chief Justice Roberts' writing, given that Justice Thomas and Alito have consistently taken the same position, given the 3 new conservative justices. But they might write it by saying that diversity is not a compelling interest, and therefore rejecting what Justice Powell said in Bakke or Justice O'Connor said for the majority. Or they might write it by broadly endorsing a principle of colorblindness. And I think there's a real difference between the two. Take as an example a school that wants in assigning students, making a law school among sections, to consider race so that the students of color are in each of the sections, but there's never just 1 or 2 alone there. Well, if color blindness is a requirement, that's not allowed. As we can talk about with regard to voting, if the court endorses color blindness, what does that mean for disparate impact liability for voting or in other areas? And third, one thing that we haven't talked about is what's going to be the practical effect if the Supreme Court rules against Harvard, North Carolina? And you can look to states like California, in Michigan, in Washington, where voter initiatives eliminated affirmative action. In California, there was a dramatic decrease in the presence of Black and Latinx students at schools like Berkeley and UCLA. In fact, it took UCLA over 20 years after Proposition 209 was adopted to get back to its pre-1996 levels of diversity. And so I think we'll see that if the court decides this, and then the questions will be, well, what other ways can schools do to achieve diversity? And of course, again, a lot is to be learned from what California, Michigan, and Washington State have done, and what hasn't worked.
Thanks, Erwin. Jeff had one quick question, then we're going to go to Pratik and Pam, and then Janai, you're going to wrap us up on this, okay? So go ahead, Jeff, real quick.
So, Erwin, your statutory constitutional point is a really good one, right? Because Seth makes a very smart move. He says, look, this is Title VI, this is statutory stare decisis. And the challengers try to come back and say, well, but you've said they're the same. So you're effectively deciding the constitutional question. So we get the benefit of the lower stare decisis standard. So I don't know if they can duck it when it comes to overruling, Fisher and Bakke at the least, whatever you think of Grutter. And on the other, it's not just disparate impact liability, right? I mean, Title VII also says you can't discriminate on the basis of race. So if this is the rule for schools and universities, what will it mean for large employers, for instance, and other institutions subject to other of the civil rights laws that have very similar, identical language. So, and it's something that the briefs don't give a lot of attention to, but it is a looming huge question.
Thanks, Pratik.
I guess one thing I would add, and picking up where Dean Chemerinsky left off, I was in the class at Volt right after Prop 209, 1 year after. That was the year after there was only one African-American student who had actually been admitted pre-Prop 209 into deferred. And then our class had a marginal rebound, a few African-American students, a few Latino students, and then it's taken a while to rebound. But what the point I want to connect to is, you know, the plaintiffs here in this case, my understanding is, say, look, no, diversity is a good thing. We want Black and Latino students. And there are other ways to do it, but those other ways are not colorblind ways, right? They point to the like 10% plans, you know, looking at things that you have to be race conscious about it, right? And in fact, in Parents Involved, when you look at what the issues are in the secondary schools, right? Justice Kennedy's controlling opinion expressly says, yes, you can be race conscious about it, just not on an individual level, right? Like you can do geographic attendance zones to get greater diversity in schools, controlled choice programs, all of that. What I think is going to happen, because I agree with Dean Chemerinsky, I think everyone who's followed this, the outcome is preordained, I think, almost, because this is the Chief's court on this issue. What's going to happen about those alternative measures that have been effectively used, at least to try to make up in areas where you can't expressly use race? That is going to be the next grounding challenge. We already see the Thomas Jefferson litigation going on, which tries to use less race-conscious measures and still attacked. And in fact, one of the judges here just heard the argument in that case in the Fourth Circuit. So I think that's going to be the next battleground. And I think some of the measures and Parents Involved and those issues are now going to be up for grabs.
Thank you. Tam?
Well, I'll just make one observation, because I think you've heard a lot here, which is part of the problem here is we've never confronted seriously getting the Reconstruction amendments actualized. If you ask yourself, why is it that using test scores or using GPAs doesn't produce a class that looks like America? There's a reason for that. And you know, the court in Bakke, there were 4 justices. It's not that a majority of the court in Bakke thought diversity in the classroom was the value we should be serving. It was that that was the way of getting a 5th justice. 4 of the justices thought the reason why you needed to have race-conscious affirmative action was that Black students and Latino students and Native American students had been discriminated against for generations, and that those communities were underserved and the like. But that has dropped out of the picture. And so instead, we have had for the last 40 or 50 years, a discussion of educational diversity as the value that affirmative action is serving. But that's not the only value that it serves. It also serves to take us beyond the country that we were and try and make us a fairer and more inclusive society. And that has been lost, I think, by the huge focus on the values of educational diversity as the sole value that schools are entitled to take into account. Second point I'll just make very briefly is, and this picks up where Pratik left off, there's going to be huge amounts of litigation after this, because there are 2 things that might happen after the Supreme Court says you can't take race into account in individualized decision-making. One is that schools will manage to keep classes that are relatively diverse. And then they're going to find lawsuits against them saying, now sub rosa, you're still taking race into account. And that's illegitimate. Or the numbers are going to drop hugely. And they're going to see litigation that says the system you're using is not fair, because a fair system would not produce a monoracial result in a multiracial, multi-ethnic society. And schools are going to face pressures there as well. So the litigation is not going to end here. Last point I'll make is just in Grutter itself, right? One of the lines that Justice O'Connor uses, she says, 25 years on, we're not going to have this anymore. And all that's really happening here is we're a half dozen years ahead of her 25-year prediction.
Thanks, Pam. The diversity of rationale, of course, was Lewis Powell's. And in 1978, the majority allowing UC Davis's use of some race conscious measures, but of course not quotas, as the ruling said, came from him. So that's why we're living in Lewis Powell's diversity world. Janai, why don't you give us some concluding thoughts before we move on to voting rights?
Sure. I'll say, I mean, the excellent points have been made about the various ways in which the court might slice this. And of course, we are deeply concerned about what the outcome would be. And the reason that I emphasized the colorblind interpretation of Brown and what pulling that thread might unravel, was underscored by Dean Chemerinsky and others. And that is, I think, the worst case scenario out of this potential decision. But I am going to maintain some hope that there will be some deference as Justice Kennedy, who's no longer on the court, obviously, created in Fisher to universities to determine their class. And I'll say, as someone who was at UCLA when Prop 209 passed, and I saw the precipitous decline of diversity in the UC system, and we talked about how hard it was to get back. We know that, even with the race neutral measures that were proposed by SFFA, African-American representation at Harvard would drop by 1/3. That is the best case scenario. Worst case scenario, it would go from 14% to 6%, and you'd see a significant decline among Latinx and Native American and Hawaiian and Pacific Islander students as well. That's another point that I will end on, and that is we talk about the Asian community as a monolith, and we must recognize that there are many Asian students within that broader group who benefit from race-conscious admission. So I am hopeful that the court will find a way to preserve the diversity rationale. I have no doubt that it will, like every test, come out a little bit different on the other side, but we will see, and we will see what the implications are for other aspects of race consciousness.
Yes, and we see the split in the Asian American community in the briefs themselves. We're going to turn to voting rights now, and Pam is going to set up Merrill versus Milligan, and then we'll get some broader thoughts from Erwin about where this court is at on the Voting Rights Act, with the Voting Rights Act, and then we'll open it up to the panelists. Go ahead.
Yeah, wither the Voting Rights Act, 2 ways of spelling it, and I think which way on that. So in 1980, the Supreme Court held in a case called City of Mobile against Bolden that the 15th Amendment to the Constitution, which prohibits discrimination on the basis of race in voting, doesn't cover vote dilution at all. And the 14th Amendment to the Constitution in its Equal Protection Clause requires showing that the challenged plan was adopted or maintained for a racially discriminatory purpose, not in spite of its effect on race, but because of its effect on race. 1982, Congress, as a statutory matter, enacted a statute that set a very different standard. The statute Congress enacted, the Voting Rights Act of 1982, the amendments of 1982, said that states and political subdivisions couldn't use voting practices or procedures, including obviously districting, in a way that results in minority voters having less opportunity than other voters to elect candidates of their choice. In 1986, the Supreme Court gave a structure to Voting Rights Act cases under Section 2 in Thornburg against Jingles, and that structure said essentially this. There's a 3-step precondition to deciding whether a challenge plan dilutes minority voting strength. The first of the Jingles factors asks whether the minority community is sufficiently large and sufficiently geographically compact so that they could form a majority in a single member district. The second 2 preconditions are flip sides of each other, and they ask whether the minority community is politically cohesive, that is, does it prefer the same candidates, is it united? And the third factor asks whether the white community votes sufficiently as a bloc so as to defeat the minority candidates of choice in the challenged plan. On top of that, or behind that, there are 9 factors that Congress identified in the legislative history in the Senate report on how you go about deciding whether under the totality of the circumstances there's minority vote dilution. That roadmap, the 3 Jingles factors and then the 9 Senate factors, has been used since 1986 across the country. It's relatively straightforward and clear cut. So that's the existing legal regime. There's one thing I want to add to that, which is when the Supreme Court in the Shelby County case struck down the special pre-clearance regime of the Voting Rights Act, it said, don't worry, Section 2 is still a nationwide prohibition on vote dilution and discrimination. So that's the legal backdrop to the case we're going to discuss right now, which is the Merrill against Milligan case. This case is, if you just take into account the pre-existing legal regime, a cookie cutter Thornburg against Jingles case. It's a challenge to the way that Alabama drew its congressional districts. Alabama is a state that's about 29% Black in voting age population. It has 7 congressional districts. Since the 1980s, it has drawn plans in which one of those congressional districts has a Black majority, voting age Black majority. It was required to do that essentially by the existing law. That is, the district was put into effect after the state admitted in lawsuits in the 1980s that it wouldn't be able to get pre-clearance for its plans unless it drew that district. That district was pre-cleared in 1990. It was pre-cleared again in 2000s. Otherwise, I think it's fair to say it's entirely possible for many of those plans, Alabama would not have drawn a single majority Black district. Cut to the 2020 round of redistricting, and plaintiffs came in and said, you know, you can draw 2 majority Black congressional districts. There's no question you can draw those districts. There are at least, I think, a half dozen plans in the record already that draw the districts. If you looked at the maps, those districts would not look odd to you on the map. They would certainly look no odder than the districts Alabama has drawn. So there's no question you can meet Jingles 1 as it's been interpreted by the courts up till now. There's also no question that you can meet Jingles 2 and 3. Alabama continues to have very high levels of racial Black voting. And there's no real question that you can show the existence of the Senate factors. So why is this case a controversial case? Well, it's controversial in part because the Supreme Court has moved more and more to this value of color blindness being an essential piece of all of its race jurisprudence. And so what the state says here is, look, you can't draw 2 majority Black congressional districts without really taking race into account. And therefore, the plaintiffs have not met the first precondition of Jingles. And one of the things that they do here, the thing that I think is striking and that has gotten a lot of the public attention, but is not really the key to the case, except in a rhetorical sense, is that social scientists now have the computational power that they can draw hundreds of thousands of districts using whatever criteria you want. And in Alabama, some social scientists ran simulations of districts, and they said if you run like 1 million simulations of districts, you never get 2 majority Black districts. You only sometimes get 1, but you never get 2. And this shows that you have to take race into account too much in order to draw 2 majority Black districts. Now, one of the ironies here of using this method to show something's gone wrong is the Supreme Court in the Rucho case said, we don't care about this method when it comes to political gerrymandering. That doesn't show anything about excessive political gerrymandering, but here it shows excessive racial gerrymandering, to use exactly the same technique. So what do I think the court is going to do here? Well, I think the court would like to cut back on Section 2 of the Voting Rights Act and would like to ratchet up what plaintiffs have to do in order to show that a plan results in a denial or abridgment of the right to vote on account of race. I don't think they're going to do it by requiring that plaintiffs run these simulations and show that you can, you know, if 1 million monkeys sitting at 1 million computer terminals using 1 million versions of Maptitude for 1 million years drew these districts, what would they look like? Because that's too costly. You can do that for statewide plans because the plaintiffs have lots of resources, but you can't do that for the local voting rights vote dilution plans that are the bread and butter of Section 2. So I don't think they're going to do that, but I think they're going to make it harder to show that an existing plan violates the Voting Rights Act under the totality of the circumstances. And they're going to do this by talking about traditional redistricting principles. And this takes me back to where I was at the very end of saying something about the affirmative action cases, which is the problem in this country is the traditional redistricting principle has been to deny minority voters the ability to elect candidates of their choice. And so when you say Alabama has traditionally drawn its districts horizontally rather than vertically in the state, or has traditionally respected the Mobile area, but not traditionally drawn across the middle of the state where the black belt is. What you're saying is the tradition of making it harder for minority voters to elect the candidates of their choice is a tradition that we are going to respect going forward. So that's where I think we are.
Okay, we're going to go to Erwin next, but then we'll hear from other panelists, starting with Jeff, just because you'll give a nice counter to the broader view that Erwin's going to say.
He has done a terrific job of presenting the case. I just make 3 observations. One is, what has Merrill versus Milligan already decided? And I think it's established something that's going to have important implications for the future. As Pam pointed out, it was a 3-judge court. And I think it's worth noting 2 of those judges that were appointed by President Trump, 1 by President Clinton. And it found the violations. The Supreme Court stayed the remedy that was imposed. And there's no indication that it applied the traditional factors for stay, like substantial likelihood of prevailing the merits and irreparable injury. Justice Kavanaugh wrote a concurring opinion saying that the court was applying Purcell versus Gonzalez. Purcell versus Gonzalez was an order from the Supreme Court in 2007 that's been taken to indicate that federal courts should not get involved in elections soon before the election. We've usually thought of that as being very soon before the election. You might remember in April of 2020, a federal court in the state of Wisconsin, right before the Wisconsin primary, extended the time for absentee ballots being turned in because of COVID, and there were so many being sent in. And the Supreme Court, using Purcell, said, no, federal courts shouldn't get involved soon before the election. But that was days before the primary. This was months before the primary and many months before the general election. If Purcell applies in this circumstance, it's going to be very difficult ever to bring a successful challenge to districting the first time those districts are used. Because there's always delay after a census before drawing districts. And would there ever then be a situation where Purcell doesn't apply? Second, how does this fit into the Supreme Court's overall jurisprudence with regard to the Voting Rights Act? I think Pam did a great job of talking about this. Let me put it in a more general way. I think there's a huge difference in our country right now between how conservatives and how liberals see the election process and see the Voting Rights Act. I think conservatives start with the premise that voter fraud is an enormous problem in the country, that the Voting Rights Act is largely no longer needed, and that the Voting Rights Act imposes a substantial burden on state and local governments. On the other hand, progressives would say that voter disenfranchisement and discrimination against voters of color is an enormous problem. The Voting Rights Act is crucial, and that voter fraud is minimal in our country. And you see how that played out in the 2 cases, Shelby County, which Pam talks about, where Chief Justice Roberts' majority opinion does say that the problem of race discrimination in voting is largely over and certainly very different than the Voting Rights Act is adopted. He does talk about the tremendous burden of preclearance on state and local governments. You see this in Bernadette versus Democratic National Committee, the case from July of 2021, where the Supreme Court gutted Section 2 of the Voting Rights Act, at least with regard to time, place, and manner restrictions. And you see Justice Alito there reading into the Voting Rights Act a concern for voter fraud that's nowhere in the statute, nowhere in the legislative history. And I think in light of the conservative views with regard to voter fraud, with regard to the Voting Rights Act, I think it's hard to see the Supreme Court affirming the 3-judge panel in this case. The third thing I would say is, well, what might the court do? Obviously, they could affirm And I think, again, as I was saying with regard to the affirmative action cases, how they reverse will be very important. One way they could do it is limiting the ability to use Section 2. Follow up Brnovich, which is time, place, and manner of the election with regard to a decision that limits the ability to find districting violation Section 2. But there's also the possibility that they could find the effects test unconstitutional. I was talking to Paul Smith, and he was suggesting that if the court wants to go down the path of saying that color blindness is required, then attention to race is required by Section 2 would be impermissible, and the effects test here would then be unconstitutional. Justice Scalia and Ritchie versus Stefano outlined this in a concurring opinion, saying that the court's going to have to confront whether an effects test under Title VII is unconstitutional because it requires attention to race. Well, this could be the same issue, and if the court were to go down that path, then it would have enormous implications for all disparate impact liability, not just with regard to the context of voting. So how they write this opinion could matter enormously, and there is the intersection between this and what we were just talking about in terms of the affirmative action cases.
Yeah, so I had two really quick thoughts because I know we've still got one case to talk about. I mean, the first is I think Erwin is certainly right that there are difficult questions about how far in advance of an election, like a primary, Purcell should apply. You know, I'm not sure that the stay means that Purcell is a dead letter because Justice Kavanaugh, joined by Justice Alito, took pains in his concurrence to try to describe the circumstances in which, in his view, Purcell would continue to apply. We can debate how meaningful those are, how often they'll recur, but he was at great pains to try to answer, I think, the argument that Erwin is making, and those two votes were necessary to what the court did. You know, I guess the only other point I'd make is, you know, I think, you know, Pam and Erwin both see this as about color blindness. And as Pam said, you know, the court would like to cut back on Section 2. And it seems to me that there's at least one other thing going on, which is, you know, the court's got this case a year ago out of Arizona called Brnovich. That's not a vote dilution case. It's a time, place, and manner case about whether you have to vote in your district and who is allowed to take your ballot in if you don't take your ballot yourself. And the court said, all right, well, look, we came up in Jingles with this, you know, fairly complicated multi-factor test drawn from a Senate Judiciary Committee report, and we don't think those factors work very well in this context. So we're going back to the text of Section 2. There is now a tension in the court's approach under Section 2. For non-vote dilution cases, there is Brnovich and what they think of as a more textually anchored approach. And for vote dilution cases, there is this the three preconditioned, then totality of the circumstances test drawn from a Senate report. So, you know, which approach is the court likely to adopt? Well, I mean, one of those accords with an interpretive methodology that the majority of them believe in, and one doesn't. So I think it is possible that they will take a different approach to Section 2, but I'm not sure it's fair to say, well, that's because they went in wanting to cut back on Section 2, as opposed to they took a different interpretive approach in Brnovich, and they may extend it to vote dilution because that's how a majority of the court believes that they ought to approach statutes.
Before we go on, I just want to check with Allie. We got a late start because of the administrative law interest that people had at the end of that one. What time should we aim for, just so I know?
Well, I will yield you another 5 minutes. How about that?
So 11:05, 11:05, okay. We want to make sure so we probably, does anybody have anything urgent to add to this before we move to the Indian Child Welfare Act case?
I'll just say two very brief things in response to Jeff. One is that the Supreme Court announced a 5-part set of factors in Brnovich that come neither from the text nor from anything Congress has said, and that Congress in 2006 ratified Jingles and the Senate report factors yet again. If you take the kind of independent communities way of thinking about statutory ratification. So, you know, the text says, does it result under a totality of the circumstances? And that's what the text says, and that text clearly repudiates the idea that you have to show a discriminatory purpose.
Janai, anything?
Yeah, if I could just say quickly, I think this case will be a significant barometer of how much confidence the public can continue to have in the court as much as any other. If we think about why this case arose in the way that it did, it is a direct descendant of the Shelby County versus Holder decision. This is the first redistricting cycle in which we no longer had the protection of preclearance. There is no way that this plan, with the disproportionate suppression of Black political power that it has, would have been able to survive preclearance. And in Shelby County, the court said that you don't have Section 5, but you still have Section 2. You can still bring these cases under Section 2 and find relief. And yet we are seeing a real threat to the ability to apply Section 2 and a narrowing of Section 2 by this court, which is really cementing for years to come a particular election that does not, and election results that do not reflect the will of Alabama's demographics as they are currently constituted. And there's no way to reverse that effect. The elections that will take place this November on those racially discriminatory lines will continue in effect, and there will be no remedy. Even if we win on this case, there will be no remedy to reverse the election outcome. And that cements warped political power and honestly creates a crisis of confidence in the court and in our political system.
Thanks. We have so much rich material here. Let's talk about the 1978 statute, Pratik, on the placement preferences for what the law calls Indian children.
Sure, Joan. So this is the Indian Child Welfare Act, which is being challenged in these consolidated cases. It hasn't gotten as much press, obviously, as the affirmative action cases or even the Voting Rights Act cases. But for those who have an interest in Indian law or practice in Indian law, this is a huge, huge case and potentially radical shift in Indian law jurisprudence. ICWA, the Indian Child Welfare Act, we call it ICWA, was passed in 1978, and it basically establishes federal rules governing custody proceedings in state court for the removal of an Indian child from his family and then placement in adoption or foster homes. Now that statute was passed after a pretty sordid history of states removing Indian children from their families, essentially decimating tribes for reasons that I don't think anyone would think were justifiable. That history, unlike in the abortion cases and gun cases and a lot of the cases these days at the court, I don't think that history is really disputed. We wrote an amicus brief for the American Historical Association, and I don't think anyone really takes issue with that history. The question is what Congress did in response in ICWA constitutional? And ICWA does a couple main things. One is it sets special procedures that have to be used in those child removal proceedings when you're dealing with Indian children. You have to use, state court has to use active efforts to try to remediate the problem, keep the child in the home. There has to be qualified expert testimony before you remove the child, and it has to have record-keeping requirements and those sort of things that monitor how often states are taking Indian children, placing them outside the home. The second set of things that ICWA does is it establishes priority for placements. And there's a good cause exception to these priorities, but absent good cause, it's three priorities. First priority is extended family, not too foreign in child custody proceedings. The second preference is to stay within the same tribe, either a family or home within the same tribe. And the third preference is any Indian tribe. So if there's nothing available in extended family or that same tribe, then you look to other Indian tribes to have preference over non-Indian families or placement. So the plaintiffs here are non-Indian couples, white couples. If Ed Blum was running it, they'd probably be Asian American couples, but they're white couples seeking to adopt Indian children. And they're joined by a couple states, Texas, Louisiana, Indiana. And the tribes, they're trying to adopt Indian children who are being removed from their families. The tribes objected. They intervened and object under the Indian Child Welfare Act. The plaintiffs bring the constitutional challenge in front of the district court. Reed O'Connor is the district judge who you may remember from Affordable Care Act fame, who struck down the Affordable Care Act in its entirety. He also ruled categorically in favor of plaintiffs essentially accepting all of their constitutional challenges and declaring the Indian Child Welfare Act unconstitutional. The Fifth Circuit eventually took it en banc and affirmed in part, reversed in part, and some of those affirmances were by an equally divided court, which is saying something in the Fifth Circuit. Now, you have multiple questions here across 4 consolidated cases. There's a 10th Amendment anti-commandeering question about imposing requirements on state courts. There's a non-delegation question that I think Erwin might have alluded to in the administrative state panel about tribes altering placement preferences. There's an Indian Commerce Clause question about can Congress regulate these child placements. But the question I want to focus on, since we're on a race panel, is equal protection. And that's the definition of Indian child. The definition of Indian child in the Indian Child Welfare Act is either a member of a tribe, you have to be a member of a tribe, or you have to be eligible to be a member of a tribe and the biological child of a tribal member. And so what the plaintiffs say is, well, that is a racial classification subject to strict scrutiny, because membership of a tribe, many tribes, or not many, some tribes base membership on your ancestry. You know, what proportion of your ancestry is from the tribe. So they say, well, look, if you're looking at that, that is a racial classification. And then the biological part of the second part of the definition, they say, is also connected to ancestry and therefore race. The response is, from those of us who practice Indian law, this is a little bit confounding because the US Code is replete with classifications. There's actually a whole title of the US Code, Indian Law Code, that refers to special classifications for Indians. And that has never been thought as racial classifications subject to strict scrutiny. Those are thought of as political classifications. This is a sovereign dependent nations, long in Supreme Court history. In fact, there's a Supreme Court case, well-established case, Moncari, that there were actually racial classifications or classifications for tribes giving them preference in hiring in the Bureau of Indian Affairs. And the court said, no, that's not a racial classification. That's a political classification. You don't get strict scrutiny. But that is really the ballgame, as you know, in most cases. Are you in strict scrutiny land, or are you in rational basis land where you would be if this is a political classification? So that's going to be the ballgame in this case. Do you take that definition of Indian child to be a racial classification? If you do, then the tribes have a big problem, because the placement preferences, while they may well satisfy rational basis scrutiny, extended family, tribe, another tribe, keep tribal connections, build up tribes, that all faces rational basis, probably does not satisfy strict scrutiny when you have adoptive non-Indian parents willing to provide a home. Does it really, is there a compelling interest to apply especially that third tier preference over that if the best interest of the child might counsel otherwise? So the ball game in this case, I think, is going to be whether you view that membership in a tribe to be a racial classification or a political classification, and it would be a significant change in the law that I think would have spillover effects within other Indian law statutes if, in fact, the court were to find that to be a racial classification. It'll be interesting to see what the court does. Obviously, Justice Gorsuch, who likely will be a vote in the affirmative action cases against the racial preferences, has shown himself to be a big ally of Indian tribes and a reliable vote in favor of tribes. So I think he will understand that distinction in Indian law. You still need a fifth vote to uphold it, but there may well be, I think, in this case. But it'll be interesting to see how it plays out. I know we're short on time.
Yeah, so we have about 2 minutes left. If anyone has any final well, what do you think? We should go to questions?
Zoom question, actually.
Okay, and then we also have one from Megan in the back.
Okay, from Zoom, someone asked, is there any way to consider and protect the interests of racial minority communities in redistricting moving forward if Milligan holds that redistricting must be colorblind? To name just an example, will communities of interest be a viable route?
Maybe you want to quickly answer that one?
Yeah, so if the Supreme Court really were to hold that you can't take race into account in redistricting, then I don't think they're going to find that communities of interest that are correlated with race, you can take that into account instead.
Megan, real quick.
So it seems like what's at stake in these cases is the ability of policymakers and private actors to solve problems that are discrimination or systemic racism, what does that toolkit look like?
Janai, you want to take that one? Did you hear it?
I could not hear it. Sorry.
Okay. What if the court goes the way everyone's imagining it will go? What is left in the toolkit of the law to solve any race discrimination? Is that what you're asking, Megan?
Systems, facts, you know, a lay of the land that is the result of racial discrimination, even if what the policymakers and private actors are trying to do is not directly address racial discrimination, right? So if you have a problem, a water system, a housing system that is a result, and an Indian law question that is the result of decades of racial discrimination, and you have problems that result from that, you still solve those problems if you're confined to a colorblind movement.
Did you hear that, Janai? Can you still solve systemic racial problems in all sorts of areas, housing, water systems, given if the court goes in this colorblind area?
Listen, I think that there are ways in which you can mitigate some of the harms that stem from racial discrimination by using non-race measures, but will you eradicate centuries of racial discrimination by not taking account of race? Absolutely not. There is no way to uproot the systemic and structural racism that undergirds this country's political, social, and economic systems without taking into account race as a fact in that entire process. Colorblindness is in no way a viable path forward in a multiracial, multicultural democracy that has been founded on racial discrimination.
Thank you all, and especially thanks to the panelists. Let's give them a round of applause.